Supreme Court, Supreme Court, Supreme Court. Woo! Yes. We're got another Supreme Court case today. We're doing Marbury versus Madison, which should be something that you've heard of from U.S. history, although maybe you haven't done it as much in depth as we're about to do it. But first, we got a card, so we're kind of all on the same page with some vocabulary. So if you would, 2.58, Writ of Mandamus. Yes, I love that. Yeah, I like to do this one in my British accent. I dare say, Writ of Mandamus. Yes, Writ of Mandamus. So you just kind of like it, just got a snooty British accent to it. I dare say, give me my writ. Yes. All right. So 2.58, Writ of Mandamus. Flip over to the back side. I said, dare say, please, thank you. All right. One, it's an order from a court. A writ of mandamus is an order from a court. You see that mandamus really kind of comes from like a Latin phrase that eventually in English you translate and it becomes mandate. It's like an order from a court. All right, a writ of mandamus. It's an order that gives a government official. It tells a government official to fulfill some sort of official duty. So let's just say, for example, you have a right to a license, and you go to the DMV, and they won't give you your license just because the person is a jerk or because of politics. They don't like who you voted for. You could theoretically, I mean, go to the court and like a writ of mandamus could be sent to the DMV, like ordering them to give you your license, driver's license. And this is really the key thing. The Judiciary Act of 1789, which was one of the first acts of Congress, of our first Congress, okay, gave Supreme Court original jurisdiction for writs of mandamus. So the Judiciary Act of 1789 gave Supreme Court, or you can write SCOTUS if you want, original jurisdiction for writs of mandamus. Remember what original jurisdiction means? It means that the Supreme Court's the first one to hear it. Like they literally have like the trial. Now, granted, for writ of mandamus, it wouldn't be so much of a trial. It would just be should the government official do it? Yes. Okay. Give an order. That's all that is. So if you wanted if you wanted to tell a government official to do something, then you would go to the Supreme Court directly. You wouldn't go to the lower courts. You would go directly to the Supreme Court. That's what this Judiciary Act of 1789 says. All right. Now, if you know that much, we are ready to rock and roll with Marbury versus Madison. So let's do it. All right. You need your yellow required Supreme Court case. We in the pair reading part, I'm going to give some key players in this case. If you want to write them down just to keep track of them, that's fine. You don't have to. You really can start writing with the unit, case, and issue. But some people like to write down these key players. So I'm just going to give a little overview of who's playing in this role in this whole case, because Marbury versus Madison can be confusing just because of the number of people that are involved here. All right. So Marbury versus Madison, that's what we're talking about. And let's rock and roll. Okay, so this is just an overview. You could put this in like the little section up top where it says pair reading. All right, so first off, John Adams. He's the lame duck president. Remember, lame duck means he's at the end of his term. He's of the Federalist Party, and he's the outgoing president. And he just lost, as you can see from the map on the right. We don't have the reds and blues because we don't have Republicans and Democrats yet. We have greens and peach. For green for the Democrat Republicans and the peach for the Federalist Party. And Jefferson is the new president. Jefferson is inaugurated. Madison, James Madison, future president, but right now he's the new Secretary of State. And he's the one who would give out orders for new judges and commissions. And that's going to be the issue here, is that there's going to be a guy appointed by Adams. So we'll talk about that in a second. And that's actually John Marshall. No, John Marshall is the old Secretary of State, and he is the new Chief Justice, had just been appointed by John Adams during the lame duck term of Congress. John Marshall will be the Supreme Court Justice who rules in Marbury versus Madison. And then lastly is a guy by the name of William Marbury. And William Marbury is an Adams appointed judge. Technically, he wasn't appointed judge. He was appointed a Justice of the Peace, which was a position that was almost like being a sheriff, but also you had some judge-like powers as well. So it's kind of a precursor to modern day policing, that you would have like a person called the Justice of the Peace who would keep track of crime and small crime, and would be able to rule on that as well. All right, so Adams appoints this guy Marbury, and so really what the critical part is that Adams uses the lame duck term of Congress after he loses in order to drive through a bunch of judicial appointees for the Federalist Party. So that way the judiciary would be filled with Federalists, even though Congress and the presidency are going to be the new Democratic, Republican, Jeffersonians. And so that's going to be an issue here. And the last person he appoints is William Marbury, the day before Jefferson is to be inaugurated. All right, so let's go on with the case. Unit 2, Marbury versus Madison, 1803. And the issue here is, can the Supreme Court issue a writ of mandamus? Can it do that? Can it just order a writ, or must it send it somewhere else? All right, must it go to London and ask the Brits for a writ of mandamus? That is the question. Just kidding. They're not going to go to Britain. All right, awesome. And then the clause, and by the way, the clause is less critical here, in terms of this, but it's Article 3. It's the section on original jurisdiction. And the principle of this case, the kind of judicial principle, is judicial review. Remember, there is no clause or amendment that says the Supreme Court has judicial review, but it is something that in Federalist 78, Alexander Hamilton explicitly talks about and says that they must do. And to be honest with you, when you look at Marbury's decision here, you're going to see some pretty big similarities between what Marbury says and what Alexander Hamilton say, which, by the way, makes sense because they knew each other and were kind of friendly. All right, so principal judicial review. All right, let's go to the facts of the case. Now, this is really critical, so make sure you get all of this. Don't write too big because we've got several things we need to have. So first off, the first issue of the day is Judiciary Act of 1789. That gave SCOTUS original jurisdiction to hand out writs of mandamus. The Judiciary Act 1789 gave SCOTUS, Supreme Court of the United States, original jurisdiction to hand out writs of mandamus. So if you wanted to order a government official to do something because you believed they were not doing their government duty, then you would go directly to the Supreme Court. In 1800 election, Adams loses to Jefferson in a close election. Adams loses to Jefferson in a close election. In the lame duck term, okay, as time ran out on Adams, he appoints William Marbury, a judge on his last day in office. So the day before Jefferson is to be inaugurated in March, back then the inaugurations happened in March of 1801, William Marbury is given and they call this a commission. Like you're given here's your commission. You are allowed to be a judge now. Here you go. And on the last day of office. So last second appointment, and Adams has signed the paper. James Madison becomes Secretary of State the next day, and he finds the commission, this order giving the right for William Marbury to be a judge or a justice of the peace. He finds it on his desk. It didn't get delivered the day before. So Madison goes to Jefferson, the new president, with this order. He says, hey, there's this order on my desk, this commission for Marbury to be a justice of the peace. What do you want me to do? And Jefferson says, ignore it. So President Jefferson tells Madison to ignore delivery of the commission. She's like, nah, screw it. He goes, they tried to pull a fast one by shoving all these judges through. We're just going to ignore this. I don't give a crap if Adams was president yesterday and it was totally legit. I'm just going to ignore it. Sorry. So that's the background here. So Marbury, who still wants to be justice of the peace, sues for a writ of mandamus. So he goes to the Supreme Court and says, hey, this is wrong. Please order Madison, Secretary of State, to deliver my commission. I have a right to it. A duly elected president at the time, Adams, gave me a commission. It was approved by Congress. I have the right. Thank you very much. So that's the background of the case. Basically, it was all, lame duck Congress and president, sort of behind the scenes politicking. Key question. There's two questions here. that are going to be answered by this case. One, does Madison have to deliver Marbury's commission? The Supreme Court is going to say yes, 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 James Madison, you do need to give it. Okay, so go ahead and deliver that. Or they're going to say he should deliver it. Okay. The second question is, can the Supreme Court issue a writ of mandamus to order Madison to do this? And this is where it gets kind of funny. The answer is no. So Marbury like wins in the sense that, yes, Marbury, you're right. They should deliver it. But then the Supreme Court says, but you know what? We can't order him to do it. So sorry. So it's kind of a funny decision in that case. And we'll look at why it is a kind of an odd decision and why it's so significant in a minute. All right. Pause it if you ever need to. All right. All right. So the vote here is a 5-0 victory for Marbury. But the Supreme Court says it doesn't have jurisdiction to issue the writ. So we agree with Marbury, but basically he's in the wrong court. This is like the equivalent of my free speech has been violated, and you go to traffic court. And the traffic court's like, yes, your speech has been violated. However, this is traffic court. And you know what? You're in the wrong freaking court. Sorry, dude. And so they just can't do anything. And that's basically what the Supreme Court says. Marbury, you know what? You're right. You've been screwed over, dude. But here's the problem: you're in the wrong court. So let's look at this in the decision, because this is where Supreme Court basically takes over judicial review. All right, so they rule that the Judiciary Act of 1789 is unconstitutional. This is first judicial review, the first case where an act of Congress is ruled unconstitutional by the Supreme Court. That's why it's so significant. Why? Well, the reason it was unconstitutional is because the Judiciary Act of 1789 expanded original jurisdiction beyond Article 3 allowed. So Article 3 very specifically said what original jurisdiction was. And it didn't state that writs of mandamus were original jurisdiction. So that meant anything Congress added to the jurisdiction of a court had to be appellate jurisdiction for Supreme Court. It couldn't be original, because original was literally spelled out in the Constitution. So they were trying to add to the Constitution, but the only way you can add to the Constitution is an amendment, and they didn't pass an amendment. Just pass the freaking law. So the Supreme Court saying like, nice, Congress. So this is kind of funny too, because look, the Supreme Court is saying no to more power, more original jurisdiction, but at the same time claiming the power to rule an act of Congress unconstitutional. So it's kind of an ironic twist there. Let's take a look at the actual Article 3 again, which we looked at before. In most cases, in all cases affecting ambassadors, other public ministers, and consuls, and those which a state shall be party, the Supreme Court shall have original jurisdiction. See that? In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as Congress shall make. So the point is that in all other cases, and a writ of mandamus would fall under all other cases, therefore, original jurisdiction does not apply, and therefore Congress can't just add on to it. And then this established judicial review of Congress laws. That is the main thing. Of course, there is no dissent because it was a 5-0 decision. So this is on one hand, Marbury wins, but he actually loses. By the way, everybody always asks, like, did Marbury ever get his commission? And the answer is no. Like, after this, he could have sued in a lower federal court, and asked for the writ, and probably would have gotten it. But at this point, he's moved on with life. This has been over 2 years since he was even appointed. So at that point, it was like, hey, look, I've moved on. I'm done. See ya. And so he never actually takes that position. All right. Thanks, guys. Make sure you study this. Use your whiteboard. Remember, you need to know the key clause, like what's the issue, the facts in the case, and the ruling. Facts and ruling are so critically important here when you're talking about Marbury versus Madison. In this case, when you're looking at the clause or amendment, there's not really that critical clause or amendment. So make sure you focus on judicial review, that being the main issue here. All right. Awesome job. Thank you. Bye.